with Washington County. He has been legal counsel for the Minnesota Sheriff's Association since 1987. He trains all over the place, including as a trainer for the National Institute of Corrections. He has a law degree and a master's in public administration. He has authored many articles and books on criminal justice, civil liability, employment, and other related issues. And as I mentioned before, he is a consultant and trainer in over 25 states for a number of national and international organizations. So please help me welcome the speaker.
Thank you. And as Liz indicated, I tend to be more of a walker around type typically. Strictly learned when I teach police command school because about 5% of all people in the United States are kinetic learners. Approximately 35 to 40% of all the cops are. So just to, if nothing else, I keep their attention by just making them wonder where I'm going next. But so I typically don't sit here for this, but you got me as you got me. We planned this long before I broke my leg. So I'm going to talk today about the Minnesota Citizens Personal Protection Act, the basics. This is a topic that for law enforcement, I teach literally a day-long class. And so far they've been complaining that it's not long enough. They want to make that into a 2-day class where we get into a lot of issues. By definition, that means you're going to get, you know, they use euphemisms like the 30,000 foot overview. This is more like the orbiter going around in terms of distance. So I tell you that in advance, not as a matter of apology, because speakers are told never to apologize at the start of a presentation. It's an explanation and an encouragement. Big room, big group, but if there are certain issues, questions, concerns you have with materials, if you think you're going to be able to have time and raise an issue at the end, we're going to be out of luck. So don't hesitate to chime in. I'm a trial lawyer. I'm used to being interrupted. I can go with the flow. We've got a lot more material on these slides than we'll even cover, but I told Liz I'll bring those, so then if people start to develop a deep abiding interest in some of these topics, you have some leisure reading. Citizens Personal Protection Act. It's commonly called the Concealed Carry Act, adopted in 2003. You can drive people like me crazy by calling it the CCW. I used to say it's like fingernails on a blackboard. My grandkids looked at me one day and said, "What's a blackboard?" So I got to come up with a new expression. But it was struck down briefly and then was reenacted in 2005. It has only been subject to a limited amount of amendments since that time, despite all the stuff going on in the legislature. The reason people like me dislike it when it's called the Concealed Carry Act, because if you have a carry permit, a permit to carry a pistol or a firearm in public, there's absolutely no requirement about concealing at all. You can walk down the streets of downtown St. Paul with your carry permit and your identification card, looking like the outlaw Josie Wales and Rambo all rolled into one. And as long as when an officer approaches you and says, "Excuse me, may I see your carry card and your driver's license," and you produce them, and you're not doing anything else wrong, you get a have a nice day and move on your way. But a lot of the political controversy about the Handgun Act and the adoption in 2003, 2005, most of the major changes that got a lot of attention were how the permit law changed. And I'll spend a little bit of time talking about changes in the permit law and the process and how many people now have permits. There are in excess of 200,000 people that we know about that legally have the authority to carry a firearm in public in Minnesota. When I say that we know about, because those are the people that show up and are in the database that the Department of Public Safety through the BCA keeps in its permit tracking system. Minnesota honors permits from about 13 or 14 other states as well. Those people don't even show up necessarily in our permit tracking system. So if they have if the person has a permit from those states, they may well be legal as well. One of the things that the act did, besides change how the permitting process works, and of course it's massively increased the number of people now with carry permits, it also took into account that there's going to be a lot of people now that probably are carrying firearms that might not have done so before. So the legislature, as part of the act, also made significant venue changes. And these venue changes, or where you can carry, where guns can be banned, these are some topics that officers are on the street often have to deal with. Somebody shows up at a particular location, they get a call of a person with a gun, then the question becomes, is that a legal person, illegal person? Is there a valid basis to make a traffic stop or an encounter. And so there's a lot of practical law enforcement, public safety, safety enforcement implications. I want to spend a few minutes just quickly covering some of what I call the venue of what the rules are about carrying in certain places. One of them, and one of the first ones in this day and age especially, is schools. Obviously, school safety is not just a Minnesota concern. At least if you listen to political rhetoric, it's a national concern. And the legislature, when it adopted the law, did make some significant modifications and changes as to what the rules are in carrying firearms onto public and private school property. If a person the general rule is carrying a firearm onto school property, whether public or private, unless one of the exceptions apply, for example, being a licensed peace officer or having the permission of the chief executive, the superintendent, or the principal of school, are two primary examples. But if you are a Joe citizen or Sally citizen and carry a firearm onto school property, you are generally committing a crime. The question is what level of crime? And Minnesota has made a two-layer criminal act. If you have a permit to carry a firearm onto school property, then you are committing a misdemeanor. If you do not have a permit to carry a firearm and you carry a firearm onto school property, you are committing a felony level offense. Now, the definition of school property is also expanded under the Act and has been now for quite some time. Might surprise a lot of people. School property for this purpose and this analysis actually includes a licensed daycare center anytime children are present. So if you drop your kids off at kinder care and your kid is there, other children are there, and you are carrying a firearm because you have a permit to carry, you drop the kid off and go off to work or whatever, you're actually committing a crime, misdemeanor offense if you have a permit, unless you have been given permission by the operator of that daycare center to be packing your firearm at the time you're on premises. And I have to tell you, as a person who handles licensing revocations for my county for daycare centers, if the licensing agencies find out that your daycare provider has given you that permission, they're going to yank their license. So, puts those daycare providers in a little bit of a dilemma for you to think about if you ever get yourself in that situation. The law as to what a school includes school buses when it's transporting children and students, whether it's for regular transportation or any school-related transportation. It includes any building under the temporary exclusive control of a school district. So, for example, we had a problem one time with out my way with a school pool that was supposed to be a swim meet. So the school district contracted with a athletic place that had a pool. If they had posted signs saying this is under temporary exclusive control of the school district, they have converted that then to school property for gun law purposes. Now, again, there are some exceptions to the general prohibition. One is the written permission of the executive. Another primary exception is for people who are licensed peace officers. So they can carry a firearm on school. When the law was first adopted in 2003, the law required that the officer actually had to be on duty on the clock. When the law was reenacted, that on-duty provision was taken out, in part because so many schools for functions were hiring off-duty police officers. And so what that did was actually determine to reduce the level of security when you could no longer hire an off-duty police officer to provide security at your school, dance, or football games, or whatever the case might be. Now, what happens though? I've got a carry permit, and let's say I'm a teacher, or let's say I'm a parent coming in for conferences or to pick up my child. I've got a carry permit. I was carrying my gun. I drive onto school property, like into the parking lot. Well, the law does allow you to keep that firearm in the trunk or rearmost area of your vehicle. So the concept is you get out of your car, you go to your trunk, if that's the kind of car, if you have a sedan, and you put the firearm in there, you're not in violation of the law. You carry it into the school itself, you are. And again, there's a preemption. Throughout most of this law, there is a preemption. State statute explicitly prevents local governments, cities and counties from enacting or passing any firearm restriction that is more stringent or more regulatory than state law. And the only exception that's been created so far to that is a court-made exception. The Metropolitan Airport Commission, in a Court of Appeals ruling, was determined not to be a city or municipality for purposes of this prohibition, nevertheless, it's a sort of a semi-private entity, but it has ordinance-making authority. So the one place that local governments can adopt an ordinance prohibiting possession of firearms on premises is MAC. It's out at the airport. But in terms of any other location, cities, buildings, county buildings, if it's more restrictive than current state law, it's declared to be void. The law does allow school districts to regulate activities of possession of firearms, ammunitions, their various components by people who work there, employees, staff members, by students, but only to the extent that a violation of the rule would be an employment standard for your staff or subject to student academic sanctions should they be in violation. So there are no criminal type consequences that exceed state law. Now, the law also was amended and updated to prohibit possession of firearms in a courthouse complex and also on the state capitol grounds. Now, there is an exception, however. Let me take courthouse complexes separate and distinct and then talk a little bit about the capitol complex, especially this building in its unique situation. So as to courthouse complexes, the statute provides that even though it's a felony to bring a firearm, dangerous weapon, or explosive device into a courthouse, you are not in violation, you're not committing any crime if you have, number one, a permit to carry a firearm, and number two, you have notified the sheriff that you will be, that you may or are entering the courthouse complex with your firearm. The key word there is notification. It does not require consent. And as long as you give that notification, you're good to go. Now, the problem with the statute from an enforcement standpoint and for the sheriffs, and as indicated, I've been part-time general counsel for the Minnesota Sheriff since 1987, because I started doing that for them when I was 12. But the problem is, well, what does that notification look like? The statute is completely silent. And so we have some individuals who have simply sent a letter or an email, if they've gotten the addresses, to all 87 sheriffs in Minnesota saying, this is to put you on notice. Someday I might show up to your courthouse, and if I do, I might have a gun. On the other hand, we have sheriffs who say, well, I need I expect to get a specific each time. And well, the problem is you can expect all you want, but we all know in criminal law, ambiguity is favored, is construed in favor of the accused. So this has been a difficult area for law enforcement to enforce, trying to figure out the courthouse complex, especially since the courthouse complexes also have a courts in them, and I'll get to that in a moment as well. Now again, there's a separate rule in place for the capitol complex. When the law was initially adopted, it was a prohibition to carry a firearm in the capitol complex, but you could legally do that if you had a carry permit and you gave notification to the Commissioner of Public Safety. So there was one particular legislator that took great delight. I won't get into the details and names, let's just say he resigned recently. But he took great delight every year in sending his notification at the start of every session to the commissioner that he was, he was a retired police officer. So he was covered by a whole different federal law anyway, but nevertheless, he did that. The legislature changed that requirement a couple of years ago. And as to the courthouse complex, if you have a carry permit, then that is deemed to be sufficient notification to the Commissioner of Public Safety that you can carry. So if you have a carry permit, there's only one potential area in this entire capitol complex by which you might be able to lawfully ban firearms. And that's when we get into the courts. It's a matter of separation of powers. The courts certainly control what happens inside whatever is declared to be the court-controlled, court judicial area in a courthouse complex out in the 87 counties. And of course, this is the judicial building. And so under that same concept of separation of powers, a court does have the authority under the power of contempt, however, to prohibit firearms, just like you could prohibit cameras in the courtroom or chewing gum or noisy newspapers or cell phones and electronic devices. The problem one has is, of course, that's only enforceable from a law enforcement perspective. That's only enforceable as a contempt, a misdemeanor contempt of court. It is not a felony, which also means typically if you're going to be prosecuted or charged, those cases are not going to be charged by the county attorney, who would normally handle gun prosecutions at the felony level. Because if you carry a firearm into the courthouse complex in Ramsey County and you walk into an area that the courts have deemed to be a judicially controlled area, you get stopped, you get arrested, it's going to be prosecuted as a misdemeanor by the city attorney rather than the Ramsey County Attorney's Office. Now in greater Minnesota, this whole concept of, well, what is, and the whole issue, what is the full extent of the judicial authority? Even the most advocates for Second Amendment, the one that think you should need even people says you should be able to carry a bazooka downtown Minneapolis and not have to worry about permits, even folks that go that far down the Second Amendment road, and that's only a slight exaggeration, by the way, of some of the folks I do deal with, seem to recognize inside the walls of the courtroom, the four walls of the courtroom, judges get to control what's going on. If you decided as a matter of judicial policy you don't want gum chewing or firearms, you're good to go. And then the consensus pretty much falls apart as soon as you walk out those doors. What about the area where the clerks are? The clerk of court, the court administrator? Well, maybe depending. Well, what about where the law library is in the county building? Well, maybe depending. And we have some counties in Minnesota that have, by court order of a district court judge or sometimes the chief judge of the district, have pretty much made an entire building a court part. This is under the control of courts and we ban firearms. I have encouraged the sheriffs who are responsible for court security to have long and hard discussions with their bench about that, because is that what they really expect, and are they going to be willing to enforce that if there's criminal prosecution? There are a couple of concerns I have from a liability standpoint. We know that judges can issue orders in their judicial capacity, whether they're legal or not. There's no civil liability. We have absolute judicial immunity as part of our legal system. Unfortunately for those poor deputy sheriffs or police officers who might be charged with enforcement of that order, if somebody decides that they are enforcing an illegal order and decides to bring a civil rights and 1983 lawsuit, they don't share that judicial immunity. And so, having an expectation by the bench that isn't realistic by the folks there in the street can be problematic. Now, again, I'm not advocating that people pull in one way or the other, but those courthouses where they have attempted to put the cloak of judicial authority over the entire building, I think, I'm going in to pay my property taxes. I'm going in to vote as an absentee. I don't care if the courts are there or not. What's your authority to try and keep me out of here, since I've already told you, Sheriff, I'm walking in with a firearm? Again, so that's a problem that we struggle with. The other weird part I've always thought about that law, the law gives you a permit to carry a firearm in public. If I walk in with 5 pounds of C4 explosive that's otherwise legal for me to possess, explosive devices, a gun permit allows me to bring an explosive device into a courts building, which I always thought was a little interesting play on language, but fortunately that hasn't happened too much yet. So what about this building? Again, you've got judicial authority, and as long as as long as you've got the ability to assert that judicial authority over the entire complex, then I think it's probably enforceable as a contempt of court. That if someone violates it and they do so in the presence of an officer, those persons could be arrested. But remember, this is not one of those misdemeanors for which a probable cause arrest is permissible. Probable cause DWI, yes. Probable cause domestic assault, yes. But this crime, if you expected a police officer to conduct an arrest of someone who is violating the rule by carrying a firearm into this building, that officer is going to have to actually experience and see the crime in progress. Just because you told them, that may give them basis, that'll give them basis under Fourth Amendment to have an encounter with the individual and go through that Fourth Amendment Terry type stop process. But it would not in and of itself give them a basis to take enforcement action until they develop their own knowledge and understanding that this person, in fact, was carrying a firearm. And again, they would not charge them under the Chapter 609 provisions we're talking about here. They would charge them, if they were going to be charged at all, with criminal contempt. And unfortunately, like I say, from a workflow standpoint, I know very few sheriff's offices and court security and building security people who have had that conversation with the city attorneys who are going to be responsible for prosecuting these cases, assuming that's all they want. That's a conversation to have with those city attorneys, not with the county attorney's offices by and large. And like I say, if you've got a carry permit, then pretty much, other than like a corrections facility, you're pretty much unable to ban firearms city halls or public works garages or public parks or any other public area. What about, so how do we know that somebody's legal or not? The statute requires if you have a carry permit and you're going to carry in public, you must have two items with you at all times. One of those being your carry permit. The other being your photographic identification, for example, your driver's license or state photo ID, your passport. Upon lawful demand of a law enforcement officer, of a peace officer, you have to display your carry permit and your identification. Now, that statute specifically says upon lawful demand of a peace officer, which means from a capital security perspective, those security staff who are not licensed peace officers, they may be doing a good, solid job for you in terms of security, but they have no legal authority under the statute. You would actually need a licensed officer to make that demand to determine if that person is in fact legal or not in terms of carrying in public. You can see that the legislature made the enforcement of this provision rather anemic. The statutory maximum for a first conviction is a $25 fine. It's a petty misdemeanor. And not only that, if the person gets a citation for not having their identification or their carry permit on them, gets their citation, if they go to the police department, sheriff's office, go to court and say, see, I had them both, by statute, the fine must be dismissed. Perhaps not surprisingly, there have been virtually almost none since 2003 citations issued under this provision that anybody can find. What about private businesses? As a guy who one of his two majors in college was political science, I was fascinated by the politics of the gun debate when this law was being passed, because there were a lot of Second Amendment advocates who also their politics were such they tended to be a lot of private property rights of protect my stuff, keep small government, some of the political rhetoric you'd hear them arguing. And I watched one debate which I actually laughed. I was entertained. So I have rights to private property, right? Yep, I can control my house, I can control my business. Absolutely, absolutely. Okay, then you agree I can tell you not to bring your gun into my business? Well, now wait a minute. Well, all of a sudden people had to decide whether 2 or 5 was winning out in terms of the amendment battle. How that played out is you can ban from your business, from your private residence, no problem whatsoever. You can prohibit whatever you want. But in terms of a commercial establishment, if I own a bakery or a drugstore or any other business, if I want to ban firearms, people from bringing firearms into my business, I can do that in one of 2 ways. One is I can walk up to somebody and tell them, take their firearm out the door and leave. Or the other is I can post signs that comply with the law. And if a person brings their firearm in violation of my signage, I see them, I say, hey, see the sign, leave, and they say no, then the crime is committed not by coming in the first place. The crime is by refusing to leave after you've been told or the sign has been pointed out to you and told you to go. So the signing is tricky. When the law was first adopted, those things popped up like mushrooms all over the place. I have by now seen, there's still a lot of them hanging around. I have yet to ever find a commercial establishment that's legally in compliance with the signing requirement, because these are the actual statutory detailed requirements. Has to be readily visible, 4 feet lateral of the entrance, the bottom of the sign 4 to 6 feet above the floor, black Arial typeface. I'm a Times Roman guy, so I screw all my signs up. I can't code right. Against a bright contrasting background color and at least 187 square inches in area, which means as a prosecutor to charge somebody with the petty misdemeanor, by the way, violation, I would have to prove every single one of those elements beyond a reasonable doubt. So I'm going to literally have to get the sign manufacturer come in and testify what type he was going to sign. I'd have to measure. So next time you go out to the Mall of America and you see all, I call them placebo signs. because they're not legally enforceable, but it may maybe make somebody feel good. But when you go into the Mall of America, look at those placebo signs that talk about how they ban guns, and then you can snicker and laugh, and you go, no, you don't. Ha ha ha. The other problem with places like malls, like the Mall of America, by statute, a landlord, even if the Mall of America wants to ban firearms, by statute, they can't require their tenants to ban firearms. So if you go into one of the stores, one of the anchor stores, and go into the mall from there, if they don't ban firearms as well, then there's no valid ban. So practically speaking, very few of these bans cases have even been attempted, or an effort has been made to enforce them. That's why I call them a placebo sign. There were some public buildings every once in a while, I still see them, that also create, we had some out in my county for quite a while. The people got tired of trying to explain it. So in public buildings, we also created placebo signs. So in our placebo signs, if you had come into, for example, the Washington County Library System for years, you'd see a big sign that said, warning, this is a public place, firearms are banned. But then, like any good lawyer, we write fine print, the small print, and underneath that it said, of course, this doesn't apply to you if you have a carry permit. But we got so tired of explaining that to people who had carry permits that we weren't really a legal sign to put them down. Hasn't made a whole lot of difference. Apparently, people don't care one way or the other. All right, and like I say, if you are a licensed peace officer, all these venue bans are not applicable to you under state law. And there's also a federal law commonly known as HR 218. It's the Law Enforcement Safety Act that applies to actively people who are peace officers in good standing, or retired peace officers who go back and continue to qualify on an annual basis, maintain their credentials. Then those individuals can basically carry a firearm and pretty much nationwide without having to worry about venue restrictions and permits, except for federal buildings. The feds cut them out of that loop, so they can still ban carrying firearms into federal buildings. Generally, if you are an employee of a political subdivision, if you are not a licensed peace officer, there's a statute outside the gun laws. It's been on the books for a long time. Statute number is 626.84, subdivision 2. I helped it get enacted way back when I was a bazillion years ago, when I was with the Attorney General's office and represented the post board, the Peace Officer Licensing Board. That statute says if you work for local government, you may not carry a firearm on the clock, on duty, unless you are a licensed peace officer. So an issue comes up with some frequency. You'll have people who work for a county or city saying, well, I've got a carry permit and I have to go into dangerous areas of the city. I want to be able to carry my handgun with me when I'm making my rounds. Sorry, unless you happen to be a licensed peace officer, you're not allowed to do that. There was one exception put into law in 2012. I worked on that, and that helped get it enacted, and that is for county attorneys and assistant county attorneys. As an assistant county attorney, I have the authority to carry a firearm while I'm on duty. Now, that doesn't give me, of course, authority to carry into the courtrooms. I want to hasten to add that. But I can carry a firearm even though I'm on the clock. If I have a carry permit, unless my county attorney has told me that as a matter of county attorney's office policy, I'm not allowed to do that. How the county attorneys come out on that varies widely across the state. You have some that are pretty adamant that under no circumstances are they going to allow it. And then you have others that have actually sponsored firearms classes, so their staff, their attorneys can go in and get a permit if they want. So if you travel around the state of Minnesota, you can see a pretty significant variation in that area. That ban does not apply to people who work for the state. So if you are a state employee, the statutory prohibition doesn't apply to you. The reason for that distinction back when the law was enacted way back when was because if it applied to state employees, they said, wait a minute, what about the guards at the correctional facilities, the correctional officers and the towers with the rifles and so on? This would disarm them, so they simply exempted out state employees from that prohibition. So to the extent the state tells its state employees that they cannot carry a firearm while they are on the clock, again, that would not be a crime to violate that rule. At most, what that would be something that's subject to employment sanctions, just like telling you you're not supposed to drive too fast in the state vehicle. Colleges and universities also may only restrict possession of firearms by students and faculty members through a non-criminal justice process. In other words, if I'm a 22, 23-year-old college student and the college has banned firearms from my classroom area where I go into class, and I'm observed in possession of a firearm, there's no criminal consequences. They could take at most academic sanctions, like if I were cheating on an exam or doing something else in violation of academic rules. That's the only enforcement. For faculty, staff, employees, again, it's an employment sanction, but nothing else. I want to spend a couple minutes just talking about changes. Another change that was enacted when the law went into effect in 2003 and 2005, and that is the criminal offense of carrying under the influence. Now that we have, like I say, being close to 250,000 people now who have firearm carry permits, the legislature said, oh, yeah, it might be on, given the fact there's 30 or 40,000 people that get caught driving drunk every year in Minnesota and prosecuted, there's probably going to be people who are carrying a firearm when they've had too much to drink. And so they adopted the carrying under the influence statute. Applies to carrying under the influence of alcohol or controlled substances. There is an implied consent procedure. So if I'm a peace officer and I have an encounter with somebody that appears to be staggering down the street, and I walk up to them because a firearm has just fallen out of their pocket, or in most of the carrying under the influence cases so far, they're driving down the road, they get pulled over for a DWI, and then it happens there's a gun sitting there on the seat next to them or whatever. A lot of these turn into DWIs and carrying under the influence. So there's an implied consent procedure. The implied consent procedure is not like the one that currently exists for DWI in a motor vehicle. In other words, it's not a crime to refuse an implied consent for carrying under the influence. This is, if anybody's been around as long as I have, you may remember the old DWI days under, it's actually, I can even give the statute numbers even then. It's 169.121, before we had a whole chapter 169A, we had an implied consent procedure that was a civil penalty. And that's what we have here. If you, let's say you have a carry permit, you are subject to an implied consent advisory, you refuse, then the consequences are a $500 civil penalty, and your permit to carry privileges are suspended for 1 year. Now that 1 year is from the date of refusal. And so one of the things we stress when we train street officers, if they run into one of these situations, it's really important for them to get the information to the issuing sheriff, the sheriff that has issued that permit. I'll talk about the permitting process here in a few minutes, because they're the ones that have the authority to enter into the system the fact that the permit has been, is now to be suspended for that 1 year period. The DWI provisions are very similar for carrying under the influence to BWI and DWI and snowmobiles, etc., but they don't cross-reference at all. If you get a DWI, that can count in the stacking toward a BWI and vice versa. This is completely freestanding. The other difference between, you're used to a .08 for the typical vehicle case. You violate the law here if you're a .04. Now that .04 comes from commercial vehicles. The commercial vehicle threshold for driving under influence, if you have a commercial driver's license, is .04 rather than .08. That's also the same for pilots, although I have to tell you, if I had a pilot with a .04, 03, I'm still not so sure I'd climb aboard that plane, but that might just be me. And like I say, the officer invokes an implied consent process. I won't get into the details of that simply from a matter of time. If there's if the charge is issued, if a carrying under influence charge is issued, the court does have, as a condition of pretrial release, have the authority to suspend the permit during the time the charge is pending. And again, violation is a misdemeanor. A second conviction can be a gross, unless the second time you get the conviction, you're still, it's only alcohol and it's 04 to 10, then it's still only a misdemeanor. As long as you keep your drinking at that level, you can have, God knows how many of these, and you don't ever get past the misdemeanor level offense. So I want to switch gears now and talk about, so people have an understanding of how the carry permit process works. There's often a lot of criticism, especially when someone with mental health or other issues goes out and does something bad, and we have trauma and harm and death and injury. Minnesota, when it issued the Citizen Personal Protection Act, essentially made us a shall issue state. It is incredibly difficult for a sheriff to deny a person the legal authority to acquire a carry permit. It's even more difficult for a sheriff or a police department to deny somebody a purchase permit. Sheriffs exclusively got into the carry permit business when the law changed. Prior to the Personal Protection Act, if you lived in a city that had a city police department, you went to your city police department to apply for your carry permit. You went to your city police department to apply for your purchase permit. Since the law has been changed, city police departments have gotten out of the carry permit business. They deal exclusively now with purchase permits. So for you to apply for a carry permit now, whether you live in a city or not, if you are a Minnesota resident, the law requires you to go to the sheriff's office in the county that you live in. If you are a non-resident, you can apply for a carry permit and get one as well in Minnesota. If you are a non-resident, you can apply for a carry permit in any county in the state that you want to. So you can imagine in a county like mine, we have hundreds and hundreds of people who live just across the St. Croix River that have carry permits issued in Minnesota, which is kind of interesting because Wisconsin was one of the last places to open up and expand who could get carry permits. So there were thousands of Wisconsin residents that had Minnesota carry permits and couldn't get one in their own state until the law changed a couple of years ago. You see a lot of, so depending on what gets you as a non-resident to Minnesota, amazing number for the size of the county, amazing number of people from North Dakota have carry permits for Minnesota that are issued by the Becker County Sheriff's Office or the Otter Tail County Sheriff's Office. Why? Because all those Fargo people have cabins over there on all those lakes around Detroit Lakes and Fergus Falls. So, well, I'm in the neighborhood, I guess I'll get a carry permit. And that's what they do. Now, this is what I mean the sheriff is very limited in discretion. The statute specifically says they must issue a permit if the applicant has the following criteria. First, have they successfully completed training in the safe use of a pistol? And I'll mention in a minute how that's determined. Are they at least 21 years of age? These are pretty much binary, yes, no. Are they a citizen or a permanent resident alien? Have they properly completed the application, completely filled it out, and paid the fees? Then they're good to go. Are they prohibited by statute from possession of a firearm? If you are prohibited by statute from possession of firearm under state or federal law, then the sheriff should not be issuing you a carry permit. Are you in the criminal gang database? That is essentially that was political cover sham, so people didn't have to think they were giving gangbangers carry permits, because to get into the criminal gang database, you almost always have to be a criminal and be disqualified for something else anyway. So there's only been one case I've found in all these years. By the way, I literally deal with all 87 counties and hundreds of cities on these issues. So I have a pretty good intelligence network, and the only case that's ever been brought to my attention where a person was disqualified because they were in the criminal gang investigative database turned out to be a mistake because they should have been removed it. So I to this day, can I tell you one person who has actually been disqualified for that? Because probably a lot of criminal gangsters don't bother to come into the sheriff's office and apply for a carry permit. They just carry anyway. It's been our cynical perspective over all these years. So these are all binary. And then the last area where there's a little bit of discretion is if the sheriff's office were to determine that issuing of the permit constitutes a danger to self or a danger to the public, then the sheriff has the authority to say no. There is no such discretion for purchase permits, only for carrying. Now, the key problem, and for sheriffs who have, and members of the community who get a little nervous about somebody, it isn't the carrying of a gun in public that the sheriff has to decide and prove if challenged in court. If the denial is based on danger to self or public, the burden of proof is on the sheriff. The burden of proof is by clear and convincing evidence. That language in that burden of proof was taken straight out of Chapter 253B, the commitment statute. And so that becomes a very difficult burden. because I have to show that this person having a carry permit is the danger, not having a firearm. Example of how difficult this can be. I have a sheriff. That's the advantage of working with all 87 of them and all 87 county attorneys. I can tell you these stories and not out any one particular entity. Sheriff had a person who had been issued a carry permit and did all the backgrounds, passed, cleared them, but then over time developed some serious mental health issues, became severely depressed, sitting around in his house one night, shot himself with a pistol, but wasn't able to inflict a fatal wound. So he's wounded, he's injured, goes to the hospital, patch him up. The sheriff says, this should be a pretty good case for danger to self or others, since he shot himself with a handgun that he had a pistol to carry. County attorneys, I agree completely. They go to court to revoke the carry permit. And this person opposes that, fights it, hires a lawyer. And after the trial, the judge said, I understand where you're coming from, sheriff and county attorney, but your petition to revoke the permit is denied. Because using sort of a but for, what if this person hadn't had a carry permit? What difference would it have made? Because you don't have to have a carry permit. You don't have to have any permit to possess a gun in your own home. So whether he had had this permit or not is irrelevant to the issue. You've shown me him having guns might not be a bad idea, but I don't have any legal authority to take away his guns, and you haven't shown me why the permit makes any difference. And that's how difficult it is in these cases. Now, after the county attorney and sheriff told me about that story, he said, you should tell people from now on, do the urban legend in reverse. You know, the old urban legend, if you shoot somebody on your front porch, drag them into your house for your self-defense claim. Well, this happens again, drag him out onto the street, because if you'd been on the street, see, you guys appreciated that more than the sheriff and the county attorney did. All right, so how do we know that somebody has been trained properly use of a pistol? Well, there are a couple of different ways. One is if they've been employed as a licensed peace officer in the past year. The other is if they present a certificate showing completion of a BCA certified approved course. The BCA, even though the statute talks Department of Public Safety, Commissioner of Public Safety, from day one, the Bureau of Criminal Apprehension, the BCA has been really the place where you go for all this information. If you're looking for forms, permits, statistics, numbers, frequently asked questions, go to the BCA portion of the Department of Public Safety website. It'll save you several clicks of your search engine. So if you've had that training and it's within 1 year of the time you apply for the pistol, then that criteria pretty much is met, assuming it's in a certified approved trainer. And the application itself, you can find all sheriff's offices have one by statute, have to have an application. It's a standardized uniform application. It is, the statute details in great detail what can be asked for, and then goes on to provide for carry permits, no other additional information can be required with one exception. And that is if you were convicted of a crime that would disqualify you from possession of a firearm and you had your firearm authority restored, then you can be required to produce that proof of restoration. But otherwise, while sheriffs can do an investigation and go to any other source to determine whether you're eligible or should be issued a permit, they're not allowed to require you to produce that information. So we have an official standardized form, very limited in what is submitted. Now, a person has to submit that form in person, and they also have to produce an accurate photocopy of their proof of training, an accurate photocopy of their driver's license or state identification card. And other than that, and pay the fee. The fee can be up to $100 for an initial application. For a renewal, it can be up to $75. If you are given a permit, then the permit, unless it's voided or otherwise revoked, it's valid for 5 years. Once you submit your permit in person, the clock starts to run for the sheriffs, and they have 30 days in which to process your permit. This is not true in every state. In North Dakota, who recently adopted a very expansive carry permit law, they didn't put any time limit on their carry permits, which is another application process, which is another reason many North Dakotans are coming to Minnesota, because North Dakota will honor a Minnesota carry permit. There are people who have had carry permit applications lingering in North Dakota for a year. So they come to Minnesota and they know that if they can get within 30 days, assuming they get the permit, then their home state is going to honor it. So we have a lot of those kind of interstate dynamics when it comes to firearms. So you get a receipt, the clock starts. The law mandates the sheriff's office do checks, a couple of different checks. They're required by law to do an electronic check through the various databases that they have access to. Sometimes people call that InstaCheck, NCIC, FBI, BCA checks they do for criminal history, looking for disqualifications. They also contact the Department of Human Services. The Department of Human Services keeps a database, which they treat as private data, so the person has to sign an informed consent as part of the application process. But the database keeps a record of anyone who has been civilly committed in Minnesota as mentally ill, mentally ill and dangerous, or chemically dependent. And the reason that database is checked is because one of the grounds that a person is not allowed to possess a firearm is if they have been judicially committed by judicial action under those provisions. So if a person has been committed under Chapter 253B, that record will exist, and that would be the grounds to deny that person a carry permit. It's also the grounds to deny them a purchase permit. Our focus now is on the Personal Protection Act. Now, when a person applies, if they applies to the sheriff's office for a carry permit, the sheriff's office is also supposed to notify the local police department, if there is one, where this person lives. The theory behind that, the policy theory behind that is many times the local police department is going to have a much higher frequency of contacts with somebody than perhaps the sheriff's office will. And so if there's concerns, for example, about behavior, mental health, perhaps aggressive behavior, assaultive behavior, the sheriff's office may not have a record of it, the police department will. But to tell you practically speaking, in the real world now, as so many cities and counties join for a unified records management system, in a lot of parts of the state of Minnesota now, the formal sending a letter has pretty much been dispensed with because the sheriff's office can just have direct access to all those local police department records anyway. But unless computer connected, that's still a requirement of law. The police have the option to respond, they're not required to. Again, the background check is done. In addition to the background check at issuance, the statute mandates at least every year, at least once a year, for every permit holder that is out there for a sheriff's office. So for example, my sheriff's office, last time I talked to them, I think had somewhere around 6,000, 7,000 permits that we've issued out of Washington County alone. Someone in that office has to do a national criminal history record check to determine if in the ensuing year these permit holders have done something that caused them no longer to be lawfully able to possess a firearm. And if that happens, then their firearm permit is voided. So that's a check that is required by law. And again, process is dictated by statute, 30 days to act upon it. And then if the person is denied a carry permit, a formal denial letter has to be sent to them explaining the grounds in detail. They have to be advised of their right to submit additional information. If they do, the sheriff has to reconsider and then either affirm the decision or change his or her mind. So if they're not happy with the no answer, then the law requires that the sheriff inform the applicant of their right to seek a de novo review. In other words, you can go to district court. The process in district court is also dictated in fair detail by statute. They get a card, it's provided to that person either in person or by mail, and then in the permit tracking system that the BCA keeps, that information is submitted to BCA. That permit tracking system is one that is available to law enforcement, prosecutors 24/7. The idea is if a police officer stops somebody at a traffic stop at 3 o'clock in the morning and that person is found in possession of a firearm, there's some question as to the legality of it, whether or not they've got a permit or not, the officer should be able to access the database through either their MDT, their mobile display terminal, through dispatch, whatever, and find out if they have a gross misdemeanor crime or no crime at all. So that's a system that works pretty well, actually. And again, if a permit is revoked or voided, that has to also be reported. So the database is, in my experience, relatively current, and it's a very useful tool. A couple other quick things that I'll talk about in terms of, as I said, 5 years. If a person changes their address, they have to notify their sheriff within 30 days. And if they don't, again, they're committing one of those $25 petty misdemeanors. Permits can become void. Permits can go away in a couple of different ways. A permit becomes void if the person gets convicted of a crime or some situation arises that now make it illegal for that person to possess a firearm. So I'll talk in the last couple of minutes about some of the common things that make it illegal for people to possess firearms. But an example is, let's say somebody's a permit holder and they get arrested, prosecuted, and convicted for a qualified domestic violence. Somebody punched out their child, caused them physical injury. That's a qualified domestic violence crime. That got convicted of misdemeanor domestic assault involving force or violence. That means they no longer, under federal and state law, they can no longer possess a firearm. So at that point, when the sheriff's office learns of that, because the prosecutor is supposed to tell them about that happening, once they know that they have a permit, then that can be voided. If, on the other hand, a person has a permit, like the example I gave you from the sheriff, where the person tried to kill themselves, that still didn't make it illegal for that person to possess a firearm. So the other way permits can go away is the sheriff, through the county attorney's office, can file a petition to revoke the permit. The petition to revoke the permit is based on danger to self or danger to the public. Same burden of proof. The county attorney has a burden of proof of proving that beyond a clear and convincing evidence standard, and as I said, the burden is on the issuing sheriff. All right, so given the time we have here, let me spend the last few minutes. Again, anybody have questions along the way about this, chime in. But otherwise, I want to talk about the primary areas of who cannot lawfully possess a firearm in Minnesota, and therefore who cannot lawfully possess, get a carry permit or a purchase permit. The mandates of who cannot possess, especially for permit processing, the people who process permits have to know intimately federal law, and they have to know state prohibition law. Because for carry permits, the law expressly provides if you are prohibited by federal law from possession of a firearm, then you're not entitled to a carry permit. They also have to be intimately familiar with state law, because state law and federal law, while they are alike in many ways, they don't completely overlap. There are people who it's completely lawful them to possess a firearm under federal law, illegal under state law, and vice versa. So one of the main areas where we see under state law, people who cannot lawfully possess a firearm get a carry permit if they have been convicted of a felony level crime of violence. A crime of violence is defined in statute in chapter 624 and 624, 712, subdivision 5. Yes, that's, I told you, I'm the sheriff's, the cops, the prosecutor's gun guy. I have these things memorized. Crimes of violence include things like murder, felony sexual assault, robbery, first and second degree burglary, theft of gun, theft of drugs, felony level child abuse, maltreatment. Major disqualifier is any felony level chapter 152 violation. So if a person has been convicted of a chapter 152 felony drug violation, the legislature statutorily has long ago declared that to be a crime of violence. That's been challenged and got in a case called State versus Craig, C-R-A-I-G, in which it was argued that that was an unconstitutional Second Amendment infringement. And the Supreme Court said, no, you know what? Drugs and guns and violence are so meshed together, interrelated, that to call a felony drug crime a crime of violence for gun law purposes is rational and it's not a Second Amendment issue. So, you lose. And that was a criminal prosecution. Felony crime of violence are a major disqualifier that law enforcement runs into. If a person has been civilly committed as mentally ill, as I mentioned already, under both federal and state law, then the law prohibits them from possession of a firearm. Now, there is a restoration mechanism potential under both of those provisions. For the mental health issue in 2008 and 2009, Minnesota legislature and Congress changed the law. So if you, for example, let's say you're committed as mentally ill, you suffer severe depression, people thought you were going to kill yourself, it's been 10, 15, 20 years, the world is way better, you've not had any issues. If you can show the court the satisfaction of the commitment court, where you had your initial commitment that your firearm authority should be restored, the court has the authority to do that. And if that's done in state court under state law, the federal government honors the state restoration. For people convicted of crimes of violence, there is a provision under Minnesota statute. It's 609.165 subdivision 1 small d that allows people to petition to restore their firearm authority. And if that they file a petition, and if they fail, hopefully they serve it on the county attorney, so the people have the opportunity to challenge, contest that if they want to. But if they prevail and they are given an order restoring firearm authority, then the federal government honors that as well. There is a significant increase in Minnesota. I can tell you anecdotally of people who have been petitioning to have firearm authority restored for crimes of violence convictions. Unfortunately, I should point to somebody in this room probably, we don't know how many, because state court administration doesn't keep track of that specific item. It's considered a sort of a miscellaneous hodgepodge when you look at case type. And so I've been tried to made contact and did a bunch of digging to say, how many of these cases are happening? I find out from all my colleague county attorneys across the state that there's a bubble up increase, but they're going, nobody knows. So, okay, so that's my sales pitch. Look at your database here going forward. But in any case, those can be restored. Do they happen? It varies widely across the state of Minnesota. Out my way, where I handle all those, it's a pretty rare event. You get up to where hunting is a national pastime, then you may see a very different perspective from the bench and police and prosecutors. Other major disqualifications, some of the probably the most prominent, the ones we hear a lot about, are domestic violence cases. There are two different laws. They used to be federal law only. As of August 1st, 2014, Minnesota built this into state law as well. We've incorporated a lot of the federal prohibitions into state law. Of the domestic violence, there are two. One is civil and the other is criminal. If you are the respondent in a 518B order for protection, and the 518B order complies with state law, one of the things it's going to do is make it illegal for you to possess a firearm while that order is in effect. Because there's been a finding that you are a person who is likely to cause harm to a domestic partner, threats of violence, you're enjoying from that type of activity. That meets federal and state criteria to make it illegal for you to possess a firearm. The criminal prosecution is under the Federal Violence Against Women's Act. And if you are convicted of a qualified misdemeanor crime of domestic violence, then you have a lifetime ban on the possession of a firearm. Qualified domestic violence crime means that the victim of your act has to have been an intimate partner. The definition of intimate partner under federal law is much more narrow than what we have in Minnesota. We talk about family or household members. So to be an intimate partner, you have to be an individual, for example, that was married to someone, have a child in common, you're a parent or a parent or guardian of a victim, or similarly situated individuals. There's federal case law that says, for example, if you're paramours, even if you haven't lived together, you would meet that criteria. But that's federal. Minnesota hasn't given us any clear indication on that, if they're going to apply that or not. At that point, if you were convicted of a domestic violence crime, or if it's a misdemeanor that has an element of violence to it, then you are disqualified. So there are two ways, for example, to commit domestic assault. One is by fear, the other is by bodily harm. If you're convicted of a domestic violence crime causing fear, you would not be disqualified. If it was by causing bodily harm, you would be. Likewise, a very large number of people who apply for carry permits and are get denied under this provision say, wait a minute, okay, I was charged with domestic assault, but I pled guilty to disorderly conduct. Well, there are two primary ways to commit disorderly conduct as well: fighting and brawling, or loud, obnoxious, boisterous, threatening words. If you're convicted under the fighting or brawling, you're going to be disqualified. If you're convicted under the other clause, you're not. And I find it entertaining sometimes when I go down and wait my turn in district court, misdemeanor, gross misdemeanor, watch the defense attorney and the city attorneys arguing back and forth. Well, he'll plead to disorderly clause 1. No, he wants clause 3, clause 1. I can tell you every single time they're fighting about the gun disqualification. According to the clock on the wall, I think we've had our hour. I burned through a lot of stuff. I hopefully gave you some things that you didn't know before, or at least for those of you who need, you got at least an hour CLE on it. So thank you all for being here. Thank you for having me.
Good.